Benson, can they hear me? Do I have to turn on main full rain, or can they hear
Yeah, I
me?
guess we're not on.
So we start with main. I can't turn them
What is
all
this
on.
doing here?
The first person is supposed to be.
I have no
Like
idea
it
what
came
it's
at my
doing.
bond out, so I'll just pass it through.
Your bond out, that's a...
Can I turn them all on to do the
Yes,
announcements?
they're all on there, yes.
All of the jails are
Yes,
on?
all the jails, even though you're only seeing the main jail.
Okay,
All of the facilities should be able to hear.
okay. So I can turn the, all right, here we go. Good morning. I am
You can
Judge
hear us,
Benson. Can everyone hear me?
Yes, Your Honor. they
Okay,
can hear
great,
you.
wonderful.
Thank you.
I am Judge Benson. We are here for your initial appearance or magistrate hearing. We are here.
Judge,
Yes, sir.
good morning.
Good morning,
I
Mr.
believe the-
Romero.
Good morning, Judge. I just wanted to let you know the volume is cutting in and out every time you lean back.
Okay,
Thank you.
so I should pull it closer? Nobody ever had to tell me I'm not talking loud enough, Mr. Romero. Okay, now can you hear me?
I can hear you.
Okay, great. Good morning, everyone. I am Judge Benson. We are here for your magistrate or first appearance hearings. We are here for several reasons. First of all, I'm going to review the charges and determine whether there is probable cause to hold you. Second, if there is probable cause to hold you, I will then determine whether or not you I will set your bond or reasonable conditions of release, or in certain conditions I might not be able to set your bond. Third, we will determine whether or not you have counsel. I am going to provisionally appoint the Office of the Public Defender to all of you for purposes of this hearing. If you or a relative has hired counsel, please let the public defender know that is with you right now. And then finally, I want to let you all know that you have a constitutional right to remain silent, that all of these proceedings are being recorded, and that the prosecutor's office is here, and that they can, at any time they desire, print a transcript or obtain a video of your appearance here and use it against you in court. So I would strongly recommend that you exercise your right to remain silent and you speak through the public defender or the lawyer that you've appointed. I also want to advise all of you that if there is a victim in your case, that you should not contact that person or any witnesses in your case, either on the phone or when you get out of jail. I want to make sure that all of you understand that each and every phone conversation you have from jail is also recorded and listened to by the Office of the Prosecutor. So don't contact anybody on your behalf and ask them to contact the victim in your case. That applies to all of you. You can also be charged with witness tampering if you try to contact the victim in your case. So with that, unless I've missed something, we are going to go to Ms. Gibson, Ms. Mary Gibson Woodard. Is she here?
Judge, I've been advised she found it.
One murder.
Okay.
And the attempt. The murders Katya's case. Did you just write what happened?
That takes us to Randy Gibson.
Oh, I did so.
Your Honor, this is a previous issue while the defendant was in custody,
Okay.
because the vehicle was not transported to the satellite location.
Who is this? Is
Okay,
this
so
No, Gibson.
we're
Randy
waiving
Gibson.
his presence?
Next one.
No, he should be there.
He's in Conte, Judge.
Oh, okay, I'm sorry, thank you.
Some excuse.
I had a little trouble getting a hold of Conte this morning. I think they might be running just a little bit behind schedule
Okay.
up there.
Is Conti there? Looks like nobody's there, so we'll pass Mr. Gibson and go to, oh, you are there. Good morning, sir.
He's coming through the door right now.
Okay, great, thank you, sir.
Your Honor, could you unlock the door, please? There's a button, no, Your Honor,
Oh, I'm sorry,
thank you.
thank you.
Trying
Good morning.
Trying to keep me out.
Yes, ma'am. Good morning.
Good morning, how are you, Mr. Gibson? I'm so sorry. This is an ad charge on a trespass that you have before Judge Miller, who is down in South Satellite.
I was here in jail and couldn't get to court.
Okay, so if he was in jail and didn't get to court, I can set a bond.
Or you can ROR him, Judge, since
Okay.
it wasn't his fault that he didn't
Okay,
show up.
That's a great idea. I'm gonna ROR you. Is your address still good, Mr. Gibson?
Yes.
That she was using for you?
Yeah. We can't just resolve this today?
Yeah, we could, Judge. It's the only thing holding him,
Okay. Stay.
right? Is that right, Randy? That's the only thing holding you? Okay.
Okay, so this is where you went, all I have is the warrant. I'm not even sure of the, facts and circumstances surrounding the case, Mr. Gibson. But if you wanna resolve it, I would withhold adjudication and sentence you to time served and tell you not to go back.
And, Your Honor, just to advise the court, the allegations in the original,
Yes, sir.
it looks like the NTA was that, Mr. Gibson was trespassing at the rear of a business located on Federal Highway in Hollywood. There had been, he'd been previously trespassed from there. There was,
Okay, so don't go back. Even though that sign probably says welcome at the top, ignore that part. Don't go back. Okay, so we are going to withhold adjudication and sentence you to time served, and I wish you well, sir.
Thank you, ma'am.
Take care, Mr. Gibson. Okay, that takes us to Eleazar Gutierrez.
I got all of them, they're just not.
Mr. Gutierrez, Ms.
Mr. Gutierrez is here present, Judge. He declined the service as a public defender.
Okay.
Nails, a few of the nails.
Good morning, Mr. Gutierrez. You are charged with violating both a misdemeanor probation and a felony probation. You will be going before Judge Pohl on October 16th on the misdemeanor. No, you've got 2 misdemeanor probations, I'm sorry. No, you do have a felony. It's a TC, 2 misdemeanors. You will be going before Judge Pohl on October 10th. I do find probable cause. Have a good day, sir. James Russell.
Mr. Russell's here present, main judge. He is approaching. Judge, in speaking with Mr. Russell, he wishes to ask the court if you would consider resolving his case today for time served.
How long has he been in?
He was arrested, yesterday, Your Honor.
Okay.
Yesterday, Judge.
Okay, Mr. Russell, I am going to withhold adjudication and sentence you to the time you've served. You plead no contest to the charges, sir?
I can't hear you.
Do you plead no contest?
What does that mean? I don't know.
Okay.
If I could have 1 second.
Yeah,
please.
take a second, sure. Can we go to the next person, Mr. Romero? Oh,
Brian,
okay.
Brian.
Kiana Stevens?
No problem, Your Honor.
Yeah,
North
if you look at the
Broward.
name he gave. Yeah, that's right.
Kiana Stevens?
Yes.
Fine if it's resolved, just if
Ms.
it's not.
Stevens, you're charged with 2 violations of community control, in a Division FI. You're going before that judge on October 10th.
I don't understand the charges. I'm sentenced for those already, Your Honor.
Judge, hold on, Ms. Stevens. Ms. Stevens is correct. It looks as though these 2 counts were part of 2 cases that she pled out to already and received 364 days in the Broward County Jail. As I explained to her, I don't know why these 2 counts weren't resolved at the same time as the other counts, but I also advised Ms. Stevens that there's probably not much this court can do about it this morning, and I will be alerting the attorney who represented her in front of Judge McCarthy so that when she goes to court on the 10th, hopefully all these things can be resolved and she can get a concurrent sentence on these 2 outstanding charges that are for some reason just dangling out there.
Ms. Stevens, I can only go on the paperwork that I have, ma'am, and McCarthy is now who?
It is Judge, it's back,
Okay,
it's back to.
I'm sorry. So you will be going before Judge McCarthy on the 10th, which is Monday, okay? So she will straighten it out. Thank you, ma'am.
Thank you.
I do find probable cause.
Good luck.
Judge, whenever you're ready, we're ready on Mr. James Russell.
Okay, so what say you, State, on Mr. Russell?
Your Honor, I have no objection to the court resolving it. If he still wants to resolve it, I don't see any Broward priors.
Okay, so Mr. Russell, how do you plead to the charge of obstructing by disguised person?
I plead no contest.
Okay, I'm gonna withhold adjudication and sentence you to the time you've served, sir. I do find probable cause and sentence you to time served. Thank you, sir. Ashley Rivera?
North
Good
Broward.
morning, Your Honor.
Good morning, Ms. Rivera.
No
Ms.
problem.
Rivera, you are charged with prostitution, possession of cocaine, and drug paraphernalia. I do find probable cause and set your bond at $300 on count 1, $1,000 on count 2, and ROR you on count 3. Thank you very much.
Judge, would you consider addressing the bond on count 2 and reducing it perhaps to 500? Ms. Rivera doesn't have any money herself, but she does indicate that her boyfriend might be able to bond her out.
State,
Your Honor, the issue is Ms. Rivera is actually out on release now on 2 separate possessions of cocaine.
so I'm gonna leave the bond. Thank you,
Okay,
Ms. Rivera.
don't say anything else, Ashley. I'll call your boyfriend, okay?
Ruby Ramirez?
I believe that's a medical reset, Your Honor.
Okay, that's what I,
Well, some call boyfriend, some use another term.
thank you. Tatiana Rivers?
No problem, Your Honor.
Okay, good morning, Ms. Rivers. You are charged with grand theft auto and 2 counts of driving while license suspended. I do find probable cause. Set your bond at $1,000 as to count 1, $750 as to count 2, and $750 as to count 3. You are to have no contact with Mr. Gene Rubin. Thank you very much. Rushan Lofton? Good morning.
Well, good morning, Your Honor. How you doing this morning?
I'm wonderful, thank you, Mr. Odom, and yourself.
I'm good. I'm good. I believe
Where is he?
he should be at the main facility.
Okay.
Mr. Lofton's here, main judge.
Mr. Lofton, I unappoint the public defender's office for you, and you are apparently retained by Mr. Odom's been retained to help you.
Not quite, Judge, but
Okay.
we'll make sure it's clear. I'm here on behalf of Ms. McLawrence's law firm. Because this is a municipal ordinance violation, we're asking the court to move and appoint provisionally Mr. McLawrence's law firm to help defend Mr. Lofton in this charge.
He shall be appointed.
Judge, I'm not going to ask to resolve. What I would ask the court to do is have the Broward Sheriff's Office to transport him forthwith to Judge Lerner Wren. He has a court appearance in front of her at 9 a.m.
Oh, this morning?
This
Okay,
morning.
The only one I saw was the 16th.
No, I didn't see the.
Mine reflects he has a status on October 16th at 2 o'clock.
I see one for 10-5, but maybe my.
It's too late for that.
Oh, I'm behind on the power curve. Okay, then correction. Not to transport him to in front of Judge Lerner Wren, but I would ask the court. I'm not going to still ask the court to resolve because apparently I believe she wants to see him. He had some issues with his conditional release terms.
Yes, sir.
I'll see if I can get him in. Mr. Lofton, I'll see if I can maybe get you in front of Judge Lerner Wren a little sooner, okay? Than the 16th. Can you hear me? Okay.
He says, all right. Okay, thank you, Mr. Lofton. I do find probable cause, and you will be going before Judge Lerner Wren. I'm sure Mr. Odom will get you there as quickly as possible.
Thank you, Judge.
Thank you, sir. Sorry I locked you out, Mr. Odom. Brandon Michael Johnson? Good morning, Mr. Johnson. You are charged with possession of cannabis of 20 grams or less. I am going to ROR you on that count, but you are also charged with a misdemeanor case under case number 17-7435 MM10A. You're supposed to go before your judge on the 13th of October, and you will be seen then. Thank you, sir.
Judge, in speaking Mr. Johnson, he wishes to ask the court if you would consider resolving both cases today.
He's on probation. I have a,
No,
oh, you've been capious. I apologize. And who's the judge on the capious?
I believe it's Judge Malika.
Yeah, okay, I don't know anything about the capious
Your
or the
Honor,
underlying charge.
I'm looking that up right now.
Okay. It's a trespass.
Yes. Hector?
Yep, section.
The only thing you might want to ask him, because I'm showing when he was originally arrested on this trespass, there was also a violation of probation. I don't know if he might want to ask him if he resolved that violation, if he's still on probation. I'm just looking out for him.
Looks like you in closing argument.
Judge, apparently,
Hey,
Mr.
Mr. Johnson.
He's already resolved his probation case.
Okay, Mr. Johnson, it's really important that you're being candid with us, because if you resolve these cases today with a plea of no contest or guilty, that can be used to violate your probation, and you've just bought yourself a lot more problems.
Ma'am, I'm being very honest
Okay.
with you. I did.
Then,
When you flip them that way.
See, I'm left-handed.
I got my son
In-
is too, it's okay.
Okay, so,
in that case, Your Honor, the allegations are that on August 11th of this year, Mr. Johnson was trespassing at a Saxon and Wall supermarket on Third Street in Pompano Beach. He had soliciting customers. He had been trespassed warrant from there previously.
how long's he spent in jail, Mr. Romero?
Well, yeah, but they also got to consider the first time he was arrested before. Yeah, I'll check that.
Okay.
Judge, I believe initially he came in, from what he's advised me, he was in for 12 days.
20
Okay,
the first time, then 12, then 1 now.
And
okay.
since yesterday.
Then I would withhold adjudication and send it you to time served. We're double checking your time served there, Mr. Johnson.
It was approximately 16 days the first time, and then
Okay.
he was arrested
Yeah.
since
So-
yesterday.
So we are gonna send it you to time served, but you can't go back to that grocery store, Saxon and Wall, okay?
Ma'am,
Okay.
I will not.
So does this resolve all of Mr. Johnson's issues?
Yeah.
Okay, so I'm going to, withhold adjudication as to both counts, the possession of cannabis and the trespass on case number 17-7435 MM10A, and send it you to time served, okay?
Thank you, Judge.
Thank
Good
you,
luck
ma'am.
to you, Mr. Johnson.
Yes, ma'am. Thank you.
Okay, that takes us to Ulysses Paz.
Mr. Ulysses Paz, come on up, please.
Pino.
I mean, you know,
Why, what's up with him?
Where's Ulysses Paz?
He's here at Main, Judge.
Okay, good morning, Mr. Paz. You are charged with petty theft by Capias on case number 16-1915 MM40. What says the state?
Your Honor, just as far as his criminal history, just to advise the court, as far as Broward, 2011 theft, 2008 battery, 99 resisting without violence. Do you have other stuff? Okay.
And how much time does he have in?
I'd have to check to see how much he was in originally. I don't even know if he was originally arrested or if there was an NTA.
Let me see. Okay,
I don't, Your Honor, the last formal arrest in Broward I see before this was 2012, so I don't believe he was originally arrested on this offense formally. Probably got an NTA. So he's been in custody since yesterday.
we have, I'd like
Judge,
to,
Mr. Paz wishes to check.
I'm gonna pull the PC.
okay, Mr. Paz, I'm trying to figure out what they're alleging that you did. All I know is they're alleging that you committed the offense of petty theft, which is an amount under $300. Do you still live at 4540 Southwest 33rd Drive in West Park?
Your Honor, can I have a moment? I think I know what happened here. I think this case might have already been resolved. Yes. What I think might have happened, this is Judge Miller's case.
Yes.
And Judge Miller will let defendants, instead of court cost, take community service hours, and she sets up a hearing to show your community service. Mr. Paz did not show up at that hearing. It's already pled out. It's just an issue of court costs at this point.
So I'm gonna
If you-
convert the cost into a civil lien, and
Read my
I'm gonna,
mind.
and I'm gonna release you, sir. And Mr. Paz, you already resolved this case, and I think a night in jail will count for your community service hours. You take care, sir, okay?
Okay.
Thank you, Judge.
Thank you.
So I'm dismissing the warrant.
Okay, what were you telling me about Pena? I should check his NCIC. He's got a warrant. Oh, or is it this warrant?
I'm just dismissing this warrant. I don't want him to come back. Apparently, this warrant was based on his failure to appear for a hearing as to whether or not
Or is
he
it the
had
other one?
completed his community service hours.
opinion.
And I think a night in jail.
Go
Well, there were two for him, so maybe it's the
Count
other
for
one.
Go down, go down.
Oh, that 9-5?
We good? Cesar Pina?
I don't, once he's in custody, we can't,
Yeah, Jimmy. In court, what are you doing? Where did you find your place?
he gets picked back up. Let's
What you can do, if this will work, is he has been served. That is true. It won't be in the system because he has been served with it, and as long as you're converting to civil liens, there's nothing else there is no future court appearances. The case is resolved,
okay.
and then just ROR him.
So, could you bring Mr. Paz back up here, Hector?
We'll
This is
go
what
ahead,
you're
yes.
talking about.
They're bringing him back, Judge.
Two cases, but nothing's been filed, but it's been just a month. You see what that's about?
But we didn't even do that case, we skipped it.
Yeah. Oh, gee.
Mr. Paz, I misspoke. I cannot dismiss this warrant because it was served. So I am RORing you and converting the fines to civil liens, which should nullify the warrant. Okay?
Okay,
Take care, sir.
thank you.
Thank you, ma'am. Okay, Cesar Pena?
He bonded.
I believe if you called Cesar Pena, Judge, he bonded.
Okay, thank you, Mr. Romero. Owen Edwards?
He's here present, Judge. I believe it's a county ordinance case.
Okay. Good morning, Mr. Edwards.
No priors?
Yes, sir.
You are charged with the violation of a county ordinance. Is there anyone, does the public defender's office represent these clients?
We cannot judge, but that does not mean that you're prohibited from resolving the case on your own if you wish to.
And Your Honor, the state does prosecute county ordinances.
Okay.
I can tell you, we checked, he has no criminal history.
Okay,
And whatever, in the court's discretion, the state's
okay,
fine.
Mr. Edwards, do you want to resolve this case, sir?
Go get that.
Should I ask for Lerner then? I don't know if you maybe want to inquire again, and if we don't get a response, maybe Judge Lerner Wren.
Mr. Edwards, how are you, sir?
Okay.
Can you hear me okay?
No,
Okay, you can't hear me very well?
right now.
Okay, do you want to get out of jail and get this case over with today?
Yes, ma'am.
I'm gonna, if you want to get out, I'm gonna withhold adjudication, which means you won't have a record of a conviction and just give you the time you've served in jail. Does that sound okay?
Yes, ma'am.
All right, then you want to plead no contest so I can do that for you?
Yeah.
Okay, then I'm gonna accept your plea of no contest, withhold adjudication, and send you, take judicial notice of the time you've already served.
Okay.
You'll get out this afternoon, okay?
Show you something.
Yes, sir.
Take care.
Thank you.
Check this out.
Michael Williams,
Yes, ma'am.
how are you, sir?
Fine, thank you.
Same thing, you are also charged with the violation of a municipal ordinance.
Yes, ma'am.
Is this a municipal ordinance or county ordinance?
It's a county
Oh,
ordinance.
okay.
Municipal, no, it says municipal city.
Yeah.
Lauderdale Lakes, is there anybody here from Lauderdale Lakes to prosecute this case? Then Mr. Augustus, Mr. Williams, I don't find probable cause. You're released.
Thank you very much.
Peter Hill,
Good Lord.
how are you, Mr. Hill?
Courtroom.
Good, good.
You're charged with violation of a municipal ordinance in Lauderdale Lakes. Is there anybody here from Lauderdale Lakes to prosecute this case? Then I don't find probable cause. You're released. Darius Hicks.
No problem, Johnny. He's a medical reset, please.
Okay. Okay, Charles Wilson.
North Broward?
Charles Wilson,
Yes.
you're charged with violating your probation. I do find probable cause. You'll be going before Judge McCarthy on October 10th. Thank you, sir.
Well, what's my proper cause?
You've been charged with violating your probation.
Yeah,
Thank
but
you.
technically.
That's all it takes. Thank you, sir. Alonzo Butts. Mr. Butts, you've been charged with burglary of an unoccupied conveyance, false owner, providing false information to the pawn shop, and dealing in stolen property. I do find probable cause. Your bond is $5,000 is to count 3, $1,000 is to count 4, and $3,500 is to count 5. Where did 1 and 2 go?
Your Honor, 1 and 2, I'll pull that right now.
Is it 2 pages?
No, he has a $5,000 bond on count
Yeah, he
one
was-
and a $1,000 bond on count
He
two.
was originally arrested, I believe, a month ago on a burglary and another charge.
Okay, so your bond then, and everybody help me, is, 10, 12, $15,500. Thank you, sir. Sion Antonio Martin,
I'm sorry, what was the bond that the court says on count 3 in Mr. Butts?
5,000, ma'am.
Thank you, Your Honor.
Yes, ma'am.
Good morning,
Good morning, Mr. Martin, how are you, sir?
All right.
Okay, you're charged with violation of your probation in, case number 17, 348 and 13-15526.
Yeah, I'm already in here for that. I was wondering how,
All right.
other cases come up.
Sir, I don't know, but I know that you're gonna be able to talk to your judge on October 10th at 9:00 a.m. in Division FP, and they'll be able to straighten that out for you, okay? Thank you, sir. Sit up here. Maker Frank Contreras.
He's at the counter, Your Honor.
Okay,
Good morning,
thank you.
Your Honor.
Good morning, Mr. Contreras. You're charged with grand theft. I do find probable cause. Your bond is $1,000. Thank you, sir.
Thank you, Your Honor.
Mohammed El Mutawakel.
North Broward.
Thank you, sir.
He's turning
Good
his mic
morning.
around.
I'm gonna call you Mr. Mohammed, okay? Good morning, Mr.
Okay.
Mohammed. You're charged with burglary of an unoccupied conveyance. I do find probable cause. Your bond is $5,000. Thank you, sir. Stephen Abraham.
Mr. Abraham, is here present, Judge of Maine.
Okay. Good morning, Mr. Abraham. You are charged with 3 counts of robbery. I do find probable cause. Your bond is set at $10,000 on each count. Thank you very much.
Your Honor, would just ask for an additional condition of no victim contact, please?
Yes, sir, and as I indicated at the outset, you are to have no contact with the victim in the case, who is,
I think there's 3. Oh,
victims in the case, David Patrick O'Connor, Menixie O'Connor, I only see 2, Counsel.
there's a second and third probable cause affidavit.
Okay. Stephen Voris. And Vladimir Nisid. Thank you, sir.
Thank you, Judge.
Judge, considering Mr. Abraham has a $100,000 bond and his other 2 outstanding cases, we would be reserving any sort of argument for bond reduction in front of his assigned judge.
Okay, thank you, sir. Nicholas Ashley, Register.
North Broward.
North Broward.
Thank you. Mr. Register, you are charged with possession of amphetamine, possession of drug paraphernalia, and failure to obey a traffic signal. I do find probable cause and impose bond in count 1 at $1,000 and RORU as to the other counts.
Like I said,
DeMonte Armstrong.
came to an emotional release.
Is here present, Judge of Maine.
Good morning, Mr. Armstrong. You are charged with robbery with a firearm. I do find probable cause and leave your bond at no bond.
Judge, are you making a finding that proof is evident and presumption is great?
That's for the
Well, Your Honor,
the trial court.
Your Honor, I would acknowledge, and I don't know if the court's had an opportunity to review Isaza v. State by the 4th DCA.
It says that's not for magistrates, correct?
No, it says it does have to be determined by magistrate for first
I
offense.
do find then that proof is evident, presumption great.
Judge, we would object to the court making that finding. Proof evident presumption grade is the highest standard that we have in criminal law, higher than proof beyond a reasonable doubt. The state has presented the court with a probable cause affidavit this morning. A probable cause affidavit is designed to establish probable cause, which is one of the lowest standards we have in the criminal court. It is not designed to hold someone no bond while awaiting trial. We would object to the court relying solely on a probable cause affidavit to establish probable cause in this particular case, stating that there is not sufficient evidence in this probable cause affidavit to hold Mr. Armstrong. And we would ask the court to set a bond for him on this case.
Your objections are noted and overruled.
And Your Honor, we'd also just, in abundance of caution, ask for an order of no victim contact in this case.
Yes, you are to have no contact with the victim in this case, even from the jail, either directly or indirectly. Don't call someone and ask them to speak to Sertana, Tony, and Barnes on your behalf. Thank you, Mr. Armstrong. Mr. Hector Mariquin.
Judge, Mr. Mariquin has private counsel, Mr. Robert.
Rich, it's, Your Honor, if I may, he's being represented by Richard Castillo, who filed a notice of appearance. I spoke with Mr. Castillo this morning. He's on his way to Hendry County, so he couldn't be here. He wanted me to advise the court, and I already confirmed this. Mr. Mariquin was actually arraigned yesterday. He understands that he's being held no bond, and that he will file for, and he wants Mr. Mariquin to know he will be filing for an Arthur hearing. And just to advise the court, Mr. Mariquin is also being held no bond on another case on a violation of pretrial.
Okay, so I do find probable cause, and Mr. Mariquin, Mr. Castillo will be in touch with you.
And Your Honor, the only thing I would ask, and just in abundance of caution, and I have the alleged victim's name, I just asked for a no victim contact order. The alleged victim's name is Jonathan Glenn.
Mr. Mariquin, you heard me at the outset, and I will reiterate that you are to have no contact with the victim, either directly or indirectly, except through your lawyer, obviously. And tell me the victim's name again, because it's been
Yes, Jonathan Glenn.
Jonathan Glenn. Jaquil Smith.
Mr. Smith, come on up, please.
Good morning, Mr. Smith. You are charged with violation of probation. You will be going before your judge in Division FH on October 10th at 9 o'clock a.m. I do find probable cause. Thank you, sir. Marvin Burrows.
And Your Honor, if before the court sets a, assuming the court finds PC, before you set a bond, just some information I want to advise the court of.
Okay.
Mr. Burrows.
Okay.
Mr. Burrows, he's being brought in right now, Judge. He's coming. He's here present, Judge.
Good morning, Mr. Burrows. You are charged with burglary of an unoccupied conveyance and loitering and prowling, and I do find probable cause. And
Your Honor, I just want to advise the court, Mr. Burrows was just arrested Monday, October 2nd for petty theft. And when he came through first appearance, he resolved his case. He was released October 3rd.
on the petty theft,
Yes.
and now he's back on this burglary. Okay.
Yes.
So, Mr. Burrows, your bond on count 1 is $5,000, and I ROR you on count 2. Thank you, sir.
Good luck, sir.
Joseph Kane.
Mr. King, come on up, please.
Appreciate it.
Good morning, Mr. Kane. You are charged with 5 counts. Charged with violating your probation in 5 different cases. I do find probable cause. You will be going before Judge Siegel on this matter on October 10th at 8:30. Thank you, sir. Andre Holman, Hoellman.
Judge, he's approaching. He declined the service as public defender. I believe his family is hiring private attorney, Mr. Johansson. Mr. Johansson.
Okay, we'll hold it. Do you have Mr. Johansson's phone number so we can make sure he's coming?
I don't have it with me.
Okay, we'll hold it as long as we can, Mr. Holman, okay?
Appreciate it.
Have a seat, sir. Michael Jablonski
Mr. Jablonski, come on up, please.
on false owner info payment items.
Yes, just to reflect the 33,000.
Okay, thank you. Good morning. Yes, sir? Wait, I can talk first. Mr. Jablonski, you are charged with burglary of an unoccupied dwelling, dealing in stolen property, false ownership, false information provided to a pawn shop, and, the second count of that. I do find probable cause. Your bond is to count one is $5,000. Your bond is to count two is $3,500. Your bond is to count three is $3,500. Your bond is to count four is $1,000, and your bond is to count five is $1,000.
And, Your Honor, the only other thing I would ask for is an order of no victim contact, no return to the property, alleged property, and the alleged victim's name is Jose Gamboa.
Mr. Jablonski, you are prohibited by this court's order from having any contact with the victim or returning to his address. Thank you very much. How do I schedule this on here? Tyler Woods. Do we need a stapler to
He's
put
here,
this
the
on?
main.
Good morning, Mr. Woods. You are charged with violation of probation. In case number 17-7867, I do find probable cause, and you will be going before Judge McCarthy on October 10th at 8:30 a.m. Thank you, sir. Mr. Kevin Harris. Mr. Harris, you are charged with resisting without violence. I'm going to ROR you on that charge, but you also have two warrants for violation of probation before Judge Colera in case number 17-6990. It should be one warrant. I guess it's one warrant, two counts. Does anybody know when he is scheduled to go before Judge Colera?
Usually, Your Honor, on,
I believe he had a court date this morning is what he's advised me, Judge.
Can we get him over to Judge Colera?
if he did, yeah, they
Yes.
just ask the deputies, they should be able to bring him over.
He has a court date in front of Judge Colera. They're gonna call him back as far as transportation?
Okay, so Mr. Harris, if you don't get before Judge Colera today, Mr. Romero will give you the phone number to call at the PD's office to try to get on the docket as soon as possible, okay?
Hey, man, they was supposed to already. I had just went in. I met with my pretrial officer yesterday about everything. So I don't see how I have a warrant.
That will be dealt with before Judge Colera. He has signed a warrant to have you brought before him, so you will go before him, okay? Thank you very much. Christopher Jones. This better not be the Christopher Jones that I think it is.
Mr. Jones? 12. He's approaching, Judge?
No, it's not. Christopher Jones, you are charged with grand theft in the amount between $300 and $5,000. Your bond is $1,000. I do find probable cause, and your bond will be $1,000. Thank you, sir. John
Judge,
Marshall.
if I could be heard, in speaking with Mr. Jones, if the state can verify, I believe this is his first contact with the criminal justice system. Right now, he's currently employed. He works at the, he was employed. He was working at a gas
Yeah,
station.
that's the
making $9.
problem.
Right.
Therein lies the problem.
So he's, well, obviously now he's not employed, so there's no sort of financial resources coming in.
Did pretrial take a look at Mr. Jones? Say it again? Oh, he has no ties to the community. He's only lived in Florida for 3 weeks, according to pretrial.
That is correct. He's from Alabama. Him and his mother both relocated from Alabama down here to South Florida. They do reside now in Fort Lauderdale. They were actually renting a room in a house, which is located in Fort Lauderdale. His mother also did obtain a job. She works at a hotel and housekeeping. Their monthly rent for this room, which they both share, is $400 a month. Judge, pre-trial, just like they're advising you that they know that he has no ties to the community, they can also look up to see if he has any sort of contacts with the system in Alabama. I would assume there's no contact.
Wait a minute, Mr. Romero. Everybody agrees that he doesn't have priors, but where is mom and where is verification of the hotel room and the? Do we have any of that? Is mom?
Just like pre-trial interviewed him, they probably took down his information and could go ahead and contact his mother and verify his address.
Okay.
So,
Okay, mom is not responding to attempts to contact.
It's like me, a good swinger, yeah.
In 3 to 5 days, if he has not yet bonded out, or if the court is inclined to sign an order pending.
Judge, we can't hear what's going on.
Then we will,
Okay, just a second, we're trying to get there, Mr. Romero. What pretrial is indicating is that I can sign an order releasing him pending verification of mom's mom's presence in the community, having a place to live, all the representations, that you are making to the court. So I would do that.
No objection from the state.
Thank you.
Okay.
Do I write that? Thank you. Okay, so, Mr. Jones, once we verify, that you're living here with your mom and you've got a good place to live, you would be released to her, but we've gotta make sure that's all, correct, okay?
All right, yes.
Thank you so much. So I'm RORing pending verification.
the bond
Okay,
pending verification.
pending verification.
Yes, Your Honor, thank you.
Thank you, ma'am. Okay, John Marshall Ireland.
John Ireland is approaching, Judge. He's all the way in the back.
Okay. Good morning, Mr. Ireland. You are charged with aggravated assault with a deadly weapon without intent to kill, second-degree petty theft, third offense. Battery, possession of cocaine, possession of paraphernalia, violating your probation on case number 15-13112, and violating your probation on case number 15-15517. I do find probable cause. I set your bond as follows: as to count 1, $2,500; as to count 2, $750; as to count 3, $1,000; as to count 4. For $1,000, as to count 5, ROR, as to count 6 and 7, no bond. You will be going before Judge Tobin Singer on October 18th on your first violation of probation hearing. Thank
And Your
you,
Honor,
sir.
we just asked for no victim contact.
Yes, you were ordered not to have any contact with the victim and not to return to the store, if I've got the right case here. Yes, you're not to return to the Akel store at 504 Northwest 6th Street, and you are not to have any contact with Mr. Foad, F-O-A-D, Akel, A-K-E-L. That takes us to Mr. Anthony Lee
Anthony
Haney.
Haney?
Yes, sir.
Mr. Anthony Haney.
Thank you.
Oh, come on up, sir.
This was the guy from the brand name watch.
He's here, President Judge.
Mr. Haney, you are charged with aggravated assault with a deadly weapon, trespass, armed trespass, and probation, violating your probation with Judge Usan in case number 16-13105 CF10A. As to count 1, I've placed your bond at $5,000. As to count 2, your bond is $1,500, and as to count 3, you have no bond. Thank you, sir.
And Your Honor,
You're going before Judge Usan on October 10th at 9 o'clock, and you are also ordered to have no contact with Shlomo Ben Shmuel, S-H-M-U-E-L, who's located, and you are not to go to... What is the name of the store?
It's brand name watch.
Brand Name Watch. Thank you, sir.
Judge,
Michael.
would you sign a book for allowing us to photograph Mr.
Absolutely.
Haney's injuries? Thank you.
Who gives me that?
So what you do?
Mr. Reedy? Okay. Make it legible, Mr. Reedy. Okay. Michael Xavier Morales.
Mr. Morales, come on up, please.
Mr. Morales, good morning, sir. You are charged with trafficking in cannabis, possession of cannabis, and possession of drug paraphernalia. I do find probable cause. Your bond is set at $75,000 on count 1, $1,000 on count 2, and $100 on count 3. Thank you, sir.
Judge, if we could be heard, and speaking of Mr. Morales, he's been residing in our community his whole life. He's 25 years old. At this time, he works in a furniture store in Miami called Mudani. He's been working at the same place of employment for 4 years now. His weekly paycheck is about $500 a week. He lives in Miami in an apartment. His monthly rent is $1,500. He lives there with his fiance and 2 children, ages 3 and 7. The only person he's going to be able to contact to post his bond is his fiance. She's a secretary, and she makes approximately $250 per week. He has no money in the bank. He does have assets. He has like a vehicle. The vehicle that he owns is a Chevy Impala 2001 with approximately 150,000 miles on it. The resale value on it, from what he advised me, is about $1,000. So there's no way he can come anywhere close to coming up with the 75,000, the 1,000, and the 100 on count 3. I'd ask you to consider reducing the bond on count 1 from 75,000 to 25,000. That's something that maybe his family or friends can try and come up with.
Your Honor, I would ask that the convenience bond be kept in place and that a more thorough bond hearing could be held in division. First of all, it would seem, based on the allegations, they don't seem to coincide with the representation that I'm sure it's information Mr. Romero received, but it doesn't seem to coincide with the representations of his finances. It appears a fully functional hydroponics lab was set up in his home with 86 plants, 77.5 pounds of marijuana. The law enforcement found numerous bank cards and credit cards, and I wouldn't understand why someone would have numerous bank cards with no money in the bank. Additionally, noting Mr. Morales' criminal history: 2012 out of Dade County battery, 2011 out of Dade burglary of a dwelling, grand theft, criminal mischief, burglary of a dwelling 2010 out of Dade County, and a theft 2010 out of Dade County.
Thank you, Mr.
Judge, the
Romero.
only thing I can say as far as what Mr. Lunder said, as far as he owns no property in Broward County. The premises that he resides in is in Dade County, Judge. So he owns no sort of home or real property or anything like that. Like I said, the only property he does own is a vehicle, which the resale value is $1,000. At this time, we're here in magistrate court, and at this time, I'm asking you not to impose a standard bond and asking you to consider his financial resources and taking that into account and determining a reasonable bond here today.
Okay, thank you, Mr. Romero. That's tonight. Your bond is 75,000 on count 1, 1,000 on count 2, and 100 on count 3.
Your Honor, regarding Mr. Christopher Jones, that the court did put pending verification. His mother did call the pretrial office moments after the hearing, and he's going to be released to our supervision.
Okay, did you hear that, Mr. Romero?
I did, but he already left, so.
Okay. Thank you, sir.
Thank you.
Timothy Pennick?
Mr. Pennick? Is he here? Oh, medical reset. Judge, I've been advised he's a medical reset.
Okay, thank you, sir. Larry Kane?
Mr. Kane, come on up, please.
No, I'm passing them through.
Mr. Kane, good morning, sir. You're charged with violation of probation in case number 15-895 CF10A. You will be going before Judge Shearer on October 11th. I do find probable cause. Thank you, sir. Jermaine Smith.
Mr. Smith, come on up, please.
Good morning, Mr. Smith. You're charged with grand theft auto, possession of cannabis, drug paraphernalia, and accessory after the fact. I do find probable cause. Your bond is $1,000 as to count 1. You are ROR'd on all the other counts. Thank you, sir. Troed Wheeler.
Mr. Wheeler, come on up, please.
Good morning, Mr. Wheeler. How are you, sir?
Good morning, how you doing?
I'm fine, thank you. You're charged with 2 counts of violation of probation, one in case number 12-957, one in case number 13-7607. You will be going before, who's Judge Hames now?
Oh, that's a good question.
Who took Hames's place?
Is it Judge Duffy?
Duffy? Judge Duffy? No, that's Prober.
Okay, then
You'll be going before the judge who took Judge Hames's place on October 10th.
I definitely said it with no certainty.
Thank you, sir. Johnny Lee Woodard.
Mr. Woodard is here present at Maine. He is approaching, Judge.
Mr. Woodard, you are charged with delivering cannabis. I do find probable cause.
Judge, once the state says what they need to say, I'm going to make.
All right, what say you, State?
Okay, Your Honor, I'm just requesting, based on Mr. Woodard's criminal history, which includes, one moment.
Tell me the years. How old are you,
of course.
Mr. Woodard?
48.
You look great.
Thank you.
You're welcome.
Actually, you know what, Your Honor, upon review, he has some serious priors. 96, an aggravated battery, was sentenced to 32-month state prison. 02, delivery of cocaine, 16-month state prison as a habitual offender. A misdemeanor possession of cannabis last year. However, based on the allegations, the alleged amount of marijuana involved, if the court, if pretrial can verify and if the court's inclined, I have no objection to release the pretrial.
Judge, unfortunately, he's homeless, so pretrial's not gonna be able to verify anything. Considering this is a nonviolent offense, he's 48 years old, he's not working, he's homeless. He's in the process of applying for disability. He's legally blind on his right eye, Judge. There's no one out there that could go ahead and potentially post his bond. I'd ask you to consider releasing him on standard pretrial, or in the alternative, an ROR.
Mr. Woodard, where are you gonna live, though? I don't wanna send you out and then we can't get a notice to you about where to come back. I'm worried.
Well, he does have a mailing address to receive his notice. The mailing address, I believe, belongs to his cousin. So he can't physically live there, however, he can receive correspondence there.
What's the address?
806 Northwest 13 Terrace.
806 Northwest.
Northwest 13 Terrace.
Is that 33311?
Yes, ma'am.
It's also the address on his booking sheet, Judge.
Okay. Oh, okay. I'm sorry. I didn't. All right, so I'm gonna release you, and you gotta check by your cousin's house, because you're gonna have to come back for court, okay? Because if you miss
Yes,
court,
ma'am.
you and me gets to see each other again like this. I don't wanna do that.
Yes, ma'am.
All right, you take care of yourself, Mr. Woodard.
Yes, ma'am.
All right, I do find probable cause, and I'm RORing Mr. Woodard.
You have to go across the street as soon as you get released, and there's pretrial. You have to check.
Clay Miller.
Give you a warrant for your arrest, all right? Okay. All right, good luck.
You're,
Who?
That last gentleman.
No, I just released him.
Mr. Romero, he's not on pretrial.
I just released him, Mr. Romero. Yes, sir.
Your Honor, I provided the court.
You're a better lawyer than you thought you
You
were.
may wanna call him back. Call him back and let him know that.
Yes, bring him back.
Because he
Mr.
just
Romero,
told
bring him back, so he knows that he doesn't have to go over there.
Actually, there was a pretrial representative here. She just stepped down and is telling him personally.
Okay, good, because I don't want him getting in some sort of trouble because he insists that he's got pretrial and then the
And Your Honor, we
security
get that
guard.
all the time in the
I
office
know, I
where
see
the
that.
public
I've seen a
defenders
couple
will.
of those. Okay,
Your Honor, Mr. Miller's case, I provided, Mr. Reedy and I provided the clerk with a copy of the affidavit for you.
oh, okay.
I just, if I could just, she's
I've
giving
got
it,
Lawrence Mitchell, I don't have,
she just handed, she just,
oh, thank you.
and I'm sure you'll want to read, if I could just have a few minutes to read the
Yeah, let
affidavit.
me have a second.
Thank you.
Can we just go off for 1 second, Mr. Romero, while I review
Yes,
this?
Judge.
Afterwards.
I know. We won't get much more than like a few kisses, so that's all for next. See ya.
What's that? No.
Yeah, I have a question while we're on it.
Yes,
about
ma'am.
This one and also about, Mr. Holman. What level is Mr. Holman and what level is Mr. Miller? Is it just a first?
No, it looks like, well, I'll check, but it looks, according to the booking sheet, this is a third.
Oh, really?
That's what it says. I'll confirm in the statute, though. Actually, let me see. You know what? I want to see what we charge, so I mean, what level offense it is. But I will advise her that we've also filed a charge. Yeah, felony of the third. But the reason I'm gonna mention that is because of the past 15 years. We've actually gone over it.
Okay, everybody else ready?
Yes, Your Honor.
Yes, ma'am.
Okay, we're ready to handle, State of Florida versus Clay Austin Miller. I've reviewed the warrant to arrest that was just provided, and I do find probable cause. The previously, set bond on the warrant of $500,000 shall remain in full force and effect. Thank you, Mr. Miller.
Your Honor, there was also a condition of pretrial with a GPS monitor. It doesn't state a level, but I'm gonna request that it be a level 1 total home lockdown, with an additional condition that there be no contact, and I'm gonna use the initials, to protect the, alleged victim's,
Minor child.
yes, and it is, one moment, Your Honor. It is, AM, and also that there be no contact, with, Michelle Granado.
I,
Judge, if, defense could be heard.
yes, sir.
In reference to the bond, which is set at $500,000, Judge, I do realize that basically that's at this point, the standard bond, that's a convenience bond. There's no way Mr. Miller can possibly come up with that. He's 50 years old, been living in our community for the past 3.5 years. He's right now on disability. He gets approximately $835. He was a registered nurse, unfortunately did suffer from an accident, I believe, some sort of motorcycle accident. He lives in Weston. He rents an apartment. The apartment cost is around $15.85 per month. He's on a lease. Besides that, Judge, this is his first arrest ever, first contact with the criminal justice system. This is a third-degree felony. He has ties to the community. He has friends, family. Particularly, he's going to be relying on a particular friend who's a realtor. But there's no way his friends can come up with $500,000. Judge, I understand the facts of the case, but at this time he is presumed innocent. Considering this is a third-degree felony, first contact with the system, lack of any sort of financial resources, the $500,000 is tantamount to no bond for this particular gentleman. We'd ask you to consider reducing the bond from $500,000 to $50,000. We wouldn't oppose a form of supervision for that added security, which if the court feels is appropriate, we'd be okay with level 2 pretrial release. But Judge, at this time, $500,000, he's going to be staying in custody until for the foreseeable future with $500,000, Judge.
Your Honor, the state would be requesting that Your Honor keep the conditions that you set in place based on the allegations of the affidavit, and I won't go into details. The court is familiar with them. I believe Mr. Miller presents a clear and present danger to the alleged minor victim, and I believe a bond in this amount is necessary to ensure that he follows the court's orders of no contact, and additionally to ensure the safety of the child.
Thank you, counsel. I am going to order
Judge,
Yes, sir.
Judge, one other, I don't know if the state has this particular information, but from what the state just said, I believe the state said their concerns for the safety of the child. Having him be on level 2, basically sort of with an ankle monitor, the court would know at all times where he's at. I believe the child is not no longer in this jurisdiction, or maybe leaving to California with the mom. So at this time, there's not going to be any sort of fear as far as him violating any sort of the court's conditions as far as contact with the child. Once again, Judge, I'd ask you to reconsider lowering the bond to $50,000.
I have reviewed the affidavit, and I do impose the bond as imposed by Judge Tobin Singer after her review of the affidavit, and I do order that he be on a level 1 monitor in the event he's released, and that he have absolutely no contact at this time with A.M. or Michelle Granado until further order of the court.
Your Honor, the only other thing I want to advise the court of, and it's really for Mr. Miller's benefit also, the state is actually, and it's referenced in the capias, the state has actually filed the charge, and I guess it's just a matter of time before the non-custody capias is served on him.
Okay, thank you, sir. Jesse Mosley.
Yeah, I know.
Mr. Mosley is here present, Judge Aming.
Good morning, Mr. Mosley. You are charged with robbery with a weapon, and my review. Okay, your bond is currently set at no bond, and I find probable cause, and I would leave the bond there. Thank you.
Your Honor,
You have to set a bond.
it's a first degree felony. It's just a hold for magistrates pursuant to the bond schedule.
Okay.
But I would advise, I would want to advise the court, I'm showing that Mr. Mosley is out on 2 separate felonies right now. One for possession of cocaine, the other for, it's a new one for me, possession of substituted cathinones. If you ask me what that is, I'll have to say I don't know.
I don't know.
Some type of
Is it-
controlled substance.
Okay, so he's currently on bond with what judge?
I believe it's Judge Howery, because that's who this case is assigned to.
Okay. As he is currently on bond for 2 other cases, I will set his bond at $50,000.
And, Your Honor, of course, we'd ask for an order of no victim contact.
You are to have no contact, Mr. Mosley, with Japheth Michael Mabson, Mabson, either direct or indirect. Thank you, Mr. Mosley.
Thank you, Judge.
I didn't make this very convenient for you. Did I miss one? I'm sorry.
So I just make a note, and I'll let the prosecutor know.
Joseph Castronova.
Yes, sir, President Judge, I may.
Thank you, sir. Mr. Castronovo, good morning, sir. You are charged with violation of probation in case number 12-6607 CF10A. You are charged with driving while license suspended as a habitual traffic offender, and you are charged with failure to attach attaching a registration that's not assigned, an expired tag, and failure to present current proof of insurance. As to count 1, you are on a no bond hold. As to count 2, I set your bond at $750, and count the other counts, I ROR you. You'll be going before your judge on October 10th at 8:30 in the morning. Thank you, sir. Jeremy Zakowski.
Mr. Jaskowski, come on up, sir.
Good morning, sir. You are charged with armed burglary of a structure or conveyance, grand theft, providing false ownership information for pawn on 2 counts, and 2 counts of dealing in stolen property. I do find probable cause. I leave your bond at no bond on count 1, $1,000 on count 2, $1,000 on count 3, $1,000 on count 4, $3,500 on count 5, and $3,500 on count 6. Thank you, sir.
Is the court sua sponte holding Mr. Zakowski no bond on count 1?
Well, it's an armed burglary, right?
That's correct.
So I'm not going to hold him no bond. I'm just not going to set a bond, and he can go for an Arthur hearing before his judge.
We would object to the court doing that sua sponte without any request by the state. And go ahead, Mr. Linder, if you
I
want to
don't
say.
believe the state has to make a request, but, Your Honor, we would be seeking a no bond hold on the punishable by life offense on count 1, arguing for, under Isaza v. State, for the purposes of first appearance, that there is proof evident or presumption great pursuant to the probable cause affidavit.
And we would object to the court making that finding, as the only document provided to the court to support that claim this morning is a probable cause affidavit, which is designed to establish probable cause, not proof evident, not presumption great. The state's called no witnesses. They've introduced no evidence. All they provided with the court with is a probable cause affidavit, which is insufficient. We would ask the court to set bond for Mr. Zakowski in count 1.
And, Your Honor, just a note, Isaza v. State is very, very clear, the fourth is very clear, that a probable cause affidavit, the state can rely upon a probable cause affidavit. It's the evidence contained therein that is what is relevant for the court's determination.
That's correct. Uzaza does allow the court to make a finding of proof evident presumption great based on a probable cause affidavit, but the court doesn't have to.
Okay, well, I do find proof evident presumption great, but I do hear the public defender's argument, and I will set his bond at $75,000.
Thank you, Judge.
Frankie Vargas.
Mr. Vargas, come on up, please.
Good morning, Mr. Vargas. You are charged with 2 counts of possession of cocaine. I do find probable cause. I will impose a bond of $1,000 on count 1 and ROR you on count 2, so your bond is $1,000. Lawrence Mitchell.
And, Your Honor, this is, if I could just, I don't know if the court has to also, if I could just have a moment to review the affidavit. I got this right before we started our docket. I provided Mr. Reedy and Your Honor with the copy.
Yes, I've reviewed it.
It is, one moment, October 1st.
Can I just point out that the face sheet lists this as a murder, and it is an attempt?
It does that, Your Honor, because they can only put the statute number for the one statute number in, and since there's no attempted murder, that's why they put in the comment section on the booking sheet attempted murder.
Okay, thank you, sir.
Yes. Attempted murder. Okay, well, are you? You don't have to, let me check to see, I can print you out a copy of the PC if it's not, it wasn't in Odyssey? Just let me know if it's not there, I'll. No, I don't think it is. I got it here. Could you go to the public defender for me, please?
We ready to proceed, counsel?
Yes, ma'am.
Yes, ma'am.
Okay, good
Thanks.
morning, Mr. Mitchell. You are charged with attempted murder in the second degree, and your bond is $50,000. I do
on
find
no
probable cause. What's his
This
estate?
is bondable.
Your Honor, Mr. Mitchell, using the AKA Joseph Mitchell, was placed on pretrial supervision on August 14th by Judge Claudia Robinson in case 17-7376 MM10A for 4 counts of larceny of a credit card. Based on this court's finding of probable cause, we're gonna ask that his pretrial status be revoked at this time.
And as far as the bond, Your Honor, if the court is inclined to consider the bond that was set by Judge Tobin Singer, the one thing I would mention, and I don't know if it was taken under consideration, one moment. Just want to make sure it's not mentioned anywhere. Yes, I don't know if it was taken into consideration as criminal history, and I would just want to advise the court of that. In addition to the felony charges, the misdemeanor charges he's out on, 2000, do you have him on the, I'm sorry, the felony case or the misdemeanor
I
case?
only have him on a misdemeanor,
He-
737.
He's also out right now, Your Honor, and I just want to make sure it's still active.
On 17-7376?
No,
That's our
a
case.
different case.
And on that time, he came in using the name Joseph Mitchell.
Yes, and he's out right now on a $2,000 bond on a filed burglary of a dwelling and grand theft. That is before Judge Dennis Bailey, and obviously it's within the court's discretion if you choose to sua sponte revoke his bond or not. Additionally, 2014 possession of cocaine, he violated probation, was sentenced to 2 years state prison. 2012 cell delivery of cocaine within 1,000 feet of a place of worship, 30-month state prison. 2011 tampering with evidence. 2008 possession of cocaine, felony theft. I'm sorry, the felony theft was dropped. On the possession of cocaine, 3-year state prison. 1997, under the name Jimmy Brown, aggravated assault on a law enforcement officer, battery on a law enforcement officer, resisting with violence, possession of hydrocodone and cocaine. He violated probation, was sentenced to 68 months state prison, had a few other possessions of cocaine in 93, battery on a law enforcement officer, 2.5 years state prison. 1986, robbery with a weapon, 12 years Florida State Prison.
What says the defense, Mr. Romero?
Judge, in speaking with Mr. Mitchell, he's been residing in South Florida his whole life. He's 52 years old. He's working in landscaping. He makes about $100 a week. He lives in Hollywood with his mother. His mother is the only person that he could contact to try and see if she could post his bond, but she's on disability. So his financial resource is quite limited for all intents and purposes. He is indigent. Judge, I do realize that the pretrial is asking you to revoke his pretrial on 177376 MM10A. And I do realize that the state did mention that he's out on a felony case right now. I'd ask you at this time to, rather than, if your honor is inclined to revoke his release, I'd ask you to consider releasing him on, or setting a bond on the misdemeanor case of $1,000. And I'd ask you to reduce the bond that's before you, Judge, from $50,000 to $10,000. That may be something more accessible to his mother, Judge.
Okay. I am going to revoke his bond in case number 17-7376 MM10A. I'm going to revoke the bond on the case before Judge Bailey, the Berg dwelling. Do we have a case number?
Yes, that is a 164516 CF10A.
And I am going to raise his bond to $100,000. Okay, thank you, Mr. Mitchell. Billy Lee Wilkerson.
Oh, you gave.
Mr. Wilkerson, your approaching judge, from what he advised me, he believes his family retained private counsel, Judge.
Okay, Mr. Wilkerson, we'll put you in the back. Do you know the name of your lawyer, sir?
Well, my mom, she should be there, because this is something they just picked me up last night.
Okay.
And I was seeing, can I get some type of help, because I know my mom there for me to at least get out, so I can try to, you know what I'm saying?
Well, that's for, those are arguments for your lawyer to make. What's your lawyer's
Yeah,
name?
because during, I don't know if my mom is there in the courtroom.
No,
they
sir.
I haven't seen his mom all morning, Judge.
What's,
Yeah,
what's
but
the lawyer's name?
I've been cooperating with the officers
No,
for
Mr.
months
Wilkerson,
now.
what is the lawyer's name?
Durham.
Duran?
His office is Durham.
Can you spell it?
Durham.
Spell his
That's
name?
the one. That's the family lawyer that my mom is going to use.
Can you?
It's him. I know Joshua's one of them. The practice is right around the corner here.
What's the? Can you spell the word the
I
Duran?
cannot spell it because I don't have this card on
Okay,
me now.
well,
All this stuff just last.
We'll wait as long as we can, Mr. Wilkerson. Have a seat.
Oh.
Frankie Francois.
Mr. Francois is approaching, Judge?
As long as you put that with the case number, they can, that's fine.
Good morning, Mr. Francois. You are charged with robbery. It indicates no firearm, but the probable cause affidavit seems to say firearm.
And that's what I wanted to address with the court, because not only does the probable cause affidavit indicate that a firearm was used, but it also alleges that Mr. Francois confessed that a firearm was used. And, Your Honor, my understanding of the law is that the court is not bound by the charge that's listed, because as you saw on Mr. Mitchell's case, that it had an attempted murder on the booking sheet. I mean, a murder on the booking sheet when in fact the allegations were for attempted murder. And just like if someone's arrested for possession of cocaine with intent, but the facts seem to suggest that it's more of a possession than a possession with intent, the court certainly has discretion to find probable cause for possession and not possession with intent. So I think the court can rely upon the factual allegations, and we would be seeking, based on the allegations and the weight of the evidence, a no bond hold for robbery with a firearm.
Mr. Romero, did you have an opportunity to review this PC?
I believe my colleague, Mr. Reedy, has.
Oh, okay. Mr.
I have,
Reed,
Judge.
Do you have any arguments in opposition to the state's position?
Unfortunately, Mr. Francois does appear to have made a very incriminating statement against himself. Without that, I think I've got a much better argument to make, but I'm going to argue before the court that, once again, if the court is going to hold Mr. Francois no bond at the state's request, you must find proof, evidence, presumption great, the highest standard we have in criminal law. The state has introduced no evidence. They have called no witnesses. We didn't find a gun. The only real evidence that there is a gun is the testimony of the victim and Mr. Francois' own testimony against himself. I would submit that that might be enough for probable cause, and it is enough for probable cause. But it is not enough for proof evident presumption great. Therefore, I would ask the court to set a bond for Mr. Francois. He's going to be held no bond on the violation of community control in any event.
Thank you, sir. I do find proof evident presumption great based on the statements and the allegations in the reports. And I will leave it at no bond, and I will find probable cause as to count 2 and impose bond of $1,000. And he has a VOP. Now, I think that's in St. Lucie County.
It is, Your Honor, and he was arrested on a 94806, so what'll happen now is Broward Sheriff's Office will notify probation in St. Lucie County, and, I'm sorry? No bond.
Okay.
And it'll be up to the probation officer, they'll go
All
to
right.
this judge.
So, Mr. Francois, I do find
No,
probable
she found
cause for your
proof of evidence
probation
was great for
violation in
robbery with
St.
the
Lucie
firearm.
County, and I'm not sure how this will go. Usually you'll resolve your charges here and then go up there, but that'll be for you to handle down the road. Good luck to you, sir.
Your Honor, and I apologize, just if I may, just in case there's a review later on of the findings today, did the court write in proof evident presumption great for robbery firearm on the findings?
Yes, sir.
Okay, thank you, Judge.
Your Honor, I'm gonna ask the court to recall Mr. Joseph Castronova.
Okay, hang on.
Thank you.
Councilor here. What page is Mr. Casanova on?
16.
Oh, there he is, thank you.
Okay. What do you want us to say to Mr. Castronova?
Your Honor, the court did find probable cause on Mr. Castronova's case. He's actually out on pretrial supervision in case 16-13199-CF10 for a manslaughter, culpable negligence. Based on the court's finding of probable cause earlier, I'm gonna ask that his pretrial status be revoked. I do understand that he does have a no bond hold from the probation violation, but this particular order will address the pretrial supervision at this time.
What says Mr. Romero?
Judge, considering he has a no bond hold on the VOP, would be deferring the argument in front of his signed judge.
Okay, so Mr. Castronova, I am gonna revoke your pretrial release on the other case that you, were being supervised on, okay?
Can I have that case number again, please?
Yes, sir. It's 16-13199 CF10A.
Yes, thank you.
Yes, sir.
Your Honor, here.
Back to you. Thank you. Okay. That brings us to Mr. Souza.
Thank you, Your Honor, for taking him out of chamber.
Wait a minute, what's going on over here? Yeah, if you touch the wrong thing on the screen, it's not showing me my jails. I got it. You can hear me? Okay, but I wanted to see. Okay, good morning, Mr. Souza. How are you, sir?
Good morning.
You're
Doing
charged.
okay.
Good. You're charged with violating probation in case number 14-7258 CF10A, and you'll be going. I do find probable cause, and you'll be going before that judge on the 10th at 8:30 a.m.
Excuse me. Can I say something really quick?
Well,
I would advise you to discuss the case, Mr. Souza.
You're not supposed to talk about your case, and basically, the warrant for violation of probation means that you should raise any issues you have before your judge. Okay?
Gotcha.
Thank you, sir.
I just have one little quick question. I know it's not much of a big deal, but it says they have a $2,000 bond, so that would be $200 with a bondsman, correct, for the violation?
I show a no bond. What have you?
I show 2,000, Judge.
Oh, you're right.
And
That's between you and a bondsman, Mr. Souza.
Thank you. I just have one quick question. I'm on pre-trial, and so I cannot leave the house, so I just wanted to know what the violation was for.
That's something you can take up on Monday with your judge.
I would really not say anything else if I were you, Mr. Souza.
All right, thank you.
Thank you, sir.
Appreciate it.
Kendrick McFadden, looks like he was a reset. He's still medical?
Yes.
All right.
Yeah,
thank
he
you,
was,
sir.
and he was just reset for bond purposes, so I have no objection to being reset for tomorrow, Judge.
Okay, thank you.
So that's,
Okay, so Mr. Holman, let's
that's just the bond.
go to Mr. Holman. He's in Maine with you, right, Mr. Romero?
Yes.
Mr. Holman, we've waited a good hour and a half for your lawyer, and no one is appearing, so we're gonna go forward.
I gave you a murder case, I need that.
You can ask, Judge, she's asking if you could reset it for this afternoon.
Counsel?
I don't have an objection.
Okay, we can reset you for this afternoon. You know his name, and we'll try to get a hold of him for you.
Yes, he was contacted, Your Honor. He was contacted here by the office.
What's his name?
Johansson, Mr. Johansson.
Johansson. Okay, Mr. Reedy, can you try to get Mr. Johansson again for the afternoon?
Can he spell the name for me? I'll call him.
Yeah, what is it?
Johansson.
Okay. I win the spelling bee. That's exactly what I wrote.
You didn't even
Johannsson.
have to ask to have it used in the sentence.
Johansson.
Country of origin.
Pretrial, did you get a phone number?
Your Honor, we actually, while the hearing was, we spoke with this partner.
Oh,
Who had contacted him and was surprised that he had not yet been here.
well, we only have 3 buildings with the same address. It's kind of tough sometimes.
I believe he said the first name of the attorney is Omar.
Yeah, we've been in touch with him. Apparently someone has, and he's supposedly on his way. Maybe we could reset him for this afternoon, Judge.
Well, let's take Mr. Wilkerson and see if he shows up in the interim.
Okay, have a seat, thank you. Mr. Wilkerson, come on up. Judge, actually, at this time, Mr. Wilkerson was actually filling out paperwork with the Public Defender's Office, so
Okay.
we're gonna be representing Mr. Wilkerson.
Okay, good morning, Mr. Wilkerson. You are currently charged with murder without premeditation, a second-degree felony. I have reviewed the probable cause affidavit and do find probable cause. What says the state?
Your Honor, the state would be seeking a no bond hold on Mr. Wilkerson for the punishable by life offense under Isaza v. State, arguing for first appearance purposes only that there is proof evident or presumption great based on the probable cause affidavit, relying upon the statements given by Mr. Wilkerson, the physical evidence not only located at the scene, but the autopsy and also statements taken from witnesses.
Mr. Reedy or Mr. Romero?
Judge, could I have just a second to review
Certainly,
the
yes, sir. Yes,
probable
sir. I'm
cause?
sorry. I thought you'd had an opportunity.
Where's that Mitchell guy? Is that it? Okay. Next thing I'm gonna show you is how to get warrant affidavits, just in case. Sometimes they make the clerk won't attach the affidavit, but we may have it in our system, it saves. I'm gonna show you how to go get it. Okay, let me find it. Let me find one that they sent me. No, I was just doing something else first. Let me find this. And this isn't how to do it, I'm just trying to get a name so I know. Oh, okay, she just did it, okay. So let's say claim number's on the document, and it's an arrest warrant. The way it's an arrest warrant, remember I was showing you where it says under warrant cases? It'll say AF, AF meaning arrest value. opposed to CF or circuit felony. So what you do is you go to documents. It might be file management for you guys. For me, document processing. Do a search under the name. Okay, so all these names come up. What you're gonna be looking for is something recent that hasn't been filed. It'll just say PR. Okay, this is pretty recent. It was presented just yesterday. So that's probably it. Click on go, and then if you're right, you'll see AF1, then it's cut off like that's arrest affidavit. Then just.
I've read the affidavit,
Okay.
Judge.
Do you have any response to the state's, assertion that proof is evident, presumption's great, and no bond should be,
I do, Your Honor. It does appear as though Mr. Wilkerson did give some inconsistent statements to the police, and I think that's probably the most damaging bit of evidence against him, quite frankly. But I would submit to the court that after an incident like this, in which, from what Mr. Wilkinson says, was a struggle over the gun, and that's when the gun was discharged, that it's more accidental, or perhaps even Mr. Wilkerson could be said to be acting in self-defense. So absent the inconsistent statements, which I think can be explained in a moment of panic or however it happens, that the idea was, well, you know, let's say this instead of say what happened, that's still not proof evident presumption great. This looks like what it all boils down to is a fight over the gun that Mr. Gay retrieved. The safety was disabled, and Mr. Gay was was shot during the course of that struggle. I don't know what the state is ultimately going to file in this case, but it certainly, to me, does not appear to be the kind of case where Mr. Wilkerson should be held no bond. Again, proof evident presumption great is the highest legal standard that we have. Based on what the court has in front of it now, with no witnesses having been called, no evidence being presented, just a bare bones probable cause affidavit, although it is quite a few pages long, this appears that there's just as much reason to believe that this is self-defense or an accident as there is to believe that it's murder, and I'd ask the court to set a bond for Mr. Wilkerson.
And Your Honor, I would just want to note, this is actually a file charge.
okay, thank you. I do find proof evident presumption great, and I will leave it at no bond. That can be revisited for you, Mr. Wilkerson. Thank you, sir. So that leaves us with Mr. Holman.
And I guess we're.
Is that correct, gentlemen?
Judge, could we recall Mr. McFadden, the last case on the docket?
Yeah.
Sure, he was a
Gotcha,
medical
file.
reset.
Yes, the jail called me, Judge. They say he's not gonna be coming to court anytime soon. They've asked the case to be reset 1 week.
Let's check back tomorrow,
Yeah.
All right,
okay? Tell him you did your best, Mr. Reed.
okay.
That just leaves us with Mr. Holman, correct?
Yes, Your Honor.
And we're back at 1:30, and so Mr.
Just gonna start at 1:30 or 1?
Whatever time you all are used to, I'll be here.
1 usually. I'm
Fine
fine.
as the norm is 1, but
Okay.
you decide.
1 o'clock. It
There you
is.
go.
I would never inconvenience the many. Mr. Holman, we'll see you at 1 o'clock, and we'll try our best to reach Mr. JOHANSSON, okay?
Send someone down.
Thank you, sir.
Thank you.
Everything good? You all need me for anything else? Absolutely.
And that's the thing, there really isn't.
Pleasure to see you.
Visa or something, or that way they,
Technically, you're supposed to find PC within
and then
48
she'll give
hours
it to you
of
guys?
your arrest.
All right, thank you.
And the problem is, and that's why I brought this in.
I have to do some adjustments on that hearing.
So you guys do this 6:30 in the morning, you get here every day?
So that's my concern.
All bright-eyed and bushy-tailed?
Did you reach someone?
Earlier? Oh.
That's okay, man. Thank you very much. You guys have a great rest of the morning, and we'll.